It's truly knowledge that set people apart. If you don't know what to do, you don't have the proper resources, you're just lost out there. And me and my husband attended one of his workshops and I was blown away. I said, I need you to show up and educate my audience.
I'm Andy Rosenberg. I'm an estate planning and elder law attorney. I've been doing it for 30 plus years.
Everything he tells you are things that you need to know to plan for yourself, to plan for someone you love, especially if you are someone from the sandwich generation, or if you have small children, if you have a spouse, someone you care about. I think that's everyone, right?
I have had several people go to multiple times to my workshops because they heard it first and then there was a lot of material and they needed to hear it a second time and more questions popped up.
Hello, everyone. If you are new here, I am Carline Cadet Francois. You know, I love for you to succeed. All I do is help you succeed in senior care. I bring you guest speakers that will educate you and show you what you need to do to find success. Please consider to like, subscribe, and follow my guests and show them some love. Today, I am so super excited. I am here with Andrew Rosenberg from Rosenberg Law Firm. When I tell you, me and my husband attended one of his workshops and I was blown away. I said, I need you to show up and educate my audience. Usually we don't do entire PowerPoint, but I promise you, pay attention, take a piece of paper, bring some notes, grab a pen, take some notes. Everything he tells you are things that you need to know to plan for yourself, to plan for someone you love, especially if you are someone from the sandwich generation, or if you have small children, if you have a spouse, someone you care about. I think that's everyone, right? So pay attention to the PowerPoint. If you have any questions, I want you to drop it in the comment below. I will make sure Andrew gets to answer your questions. And towards the end, I will be asking him some questions. You want to stay so you can listen to the questions and how he's going to answer those. And without further ado, I will let Andrew introduce himself.
All right, so good morning, everybody, or good evening, depending on when you're listening to the podcast. I'm Andy Rosenberg. I'm an estate planning and elder law attorney. I'm located in Coral Springs, Florida. I handle the entire state of Florida for my clientele. I'm an old man. I've been doing it for 30 plus years, and I'm originally from Indianapolis, Indiana. I married my wife from college. We met at Indiana University, and she's from South Florida, and that's how I ended up down here in South Florida. So the goal today is for me to quickly go through my presentation, and I will tell you guys that the presentation itself is normally about an hour and a half presentation. I'm going to try and do this in about 25 minutes. So we're going to really go flying through this. If you really want to have a better understanding of the whole process, you need to come to one of my workshops. You can contact the office at 954-755-7803, or you can email us at Andrew@Rosenberg, Rosenberg, RosenbergLawFirm.net. Again, Andrew@RosenbergLawFirm.net. I do these workshops on average about every 2 weeks in the South Florida region. Without further ado, we're going to talk about everything in the workshop very quickly.
Sounds good. I'm excited.
Right. You got it. So the topic of the workshop is estate planning essentials. First slide you see are the goals that I typically go through. I talk about what happens if you don't plan at all. A will guarantees probate. We're going to talk about that. We're going to talk about titling of assets. We're going to talk about something people don't even know about most of the time. It's called ladybird deeds, and that's a very unusual situation for Florida. Then we're going to talk about what I consider the 4 most important estate planning documents. They're not going to be what you think it is, guys, but it's what I consider the foremost. Then we're going to talk about trust. We're going to talk about the funding process of trust. And then we're going to talk about Medicaid planning, which is so important, as Carline knows. So let's get into it. So here, number one, I want you to realize, guys, everyone that's listening out there, you don't need to have $1 million to do an estate plan, okay? Everybody needs an estate plan, including your kids that have turned 18 years of age. So I always tell all my clients, anyone that's turned 18 and they're going off to college, those college kids need estate planning because God forbid if something happens to them and they get in a car accident and you need to talk to the doctors and they're in another city or state, you're not going to be able to talk to those doctors because they're an adult. They're 18 years of age without the proper legal documents. So my point is that people have this conception out there, Carline, that you have to have $1 million to do an estate plan. It's meant for everybody. You can have 100,000, 10,000, no money. Most 18-year-olds have no money. So that gives you an idea that this is meant for everybody. So now, first topic, if you don't plan. So what that means is what happens if you were to not have any estate plan whatsoever? You didn't have a will, you had nothing, and you passed away. The legal term that we call that is called dying intestate, dying without a will, intestate. And what you need to know is that the state of Florida is going to determine how your assets go, unfortunately. So if you don't plan, that's the worst thing in the world you could do, because you have no control over the assets and the state of Florida is going to control it. I actually just finished writing a book, and it's in the final stage of editing and getting ready to be printed. The title of it's not If You Don't Plan, but it kind of is. I have this saying that I do all the time on my videos when I shoot videos and at the end of my workshops and everything else. So don't get offended, anyone. But I always say this, and I tell people at the end, I look in the camera, or I look at them, and I say, remember, if you don't plan, you're stupid. And this is true more than anything in regards to this first slide. If you don't plan at all, that's not very smart. You're going to have Florida control everything, and you're not going to be involved with it. So I have a book called If You Don't Plan, It's Stupid. I have a podcast coming out called If You Don't Plan, You're Stupid. And then I trademarked it. So I'm in the process of trademarking that phrase. That's how often I use it. I'm not playing.
You're not playing. Share with us. Once the book comes out, share it with us. We'll go back and add it to the show notes. I'll be excited to read it.
You got it. So again, what happens if you don't plan, if you don't have any estate plan? It's called dying intestate. And what happens is the state of Florida has a statute called the Florida Intestate Statute. And the state of Florida is going to tell us how the assets go when you pass away. And so that's never a good thing, especially if you're in a blended marriage situation. You're in a second marriage, third marriage, you got kids from prior relationships, etc. It's never going to go how you want it to go. So the worst thing you could do is die with no plans whatsoever. So if you want to learn something, please at least meet with someone to do your simple estate plan if that's what is required. In addition, what you need to know is that if you have assets in your name alone and you pass away with no estate plan, you're going to go through this probate process. And we're going to talk about that in a minute. So with dying, if you don't plan, with no estate plan, no will, you're going to have intestate, dying without a will, you're going to go through probate, and the state of Florida, through their Florida statute, is going to determine how the assets go. So that's the first topic. Now let me get to what is the core. So this is a core slide that I really talk about a lot in the workshop. And I tell people, listen, this entire presentation that I'm talking about is about this one slide. What actually is estate planning? And it's three core elements. Number one, who's in control? That's what we want to know. Who's going to be in control if something happens? Who also gets the benefit of the control and the benefit of the assets? And when do they get the benefit? Is it while you're alive and well? Is it when you become disabled or incapacitated? Or is it when you pass away? So when I'm talking about all these things that we're talking about here, Carline, you need to think of this slide through the whole process and understand that this is what estate planning is about. So again, we talked about the first topic, if you have nothing. The second topic is if you have at least a will, the basics. So if you have a will, I used to do workshops 30 years ago, and I stopped for 29 years. And just picked up again this past year. This used to be the only slide when I did my workshops 30 years ago. And I would just draw on the old chalkboards or the whiteboards that we used to have. I'd draw the word wills equals probate, and then I'd talk for an hour about that. So literally it's something you could talk about for an hour. But what you need to understand is that people think that if they have a basic will, that everything's going to be fine. And that's false, because unfortunately they think of it like the movie. So I just finished watching not that long ago for a second or third time, a movie called Gran Torino by Clint Eastwood. Great movie. Spoiler alert, at the end, he dies. Okay? And in the movies, like all the movies, they end up going to an attorney, and the attorney reads the will, and then everyone gets their assets, and then it goes to the credits, end of the movie. That's not how it works, okay? That's the movies. That's not real life. So what happens, guys, when you have a will, you're also going to guarantee probate, which is not something we want to go through. And the term we use if you have a will is called testate. If you die without a will with no plan, it's called intestate, and you're guaranteed probate. If you die with a will, it's called testate, and you're guaranteed probate. Well, what is probate? Probate is a court process. That's all it is. Unfortunately, it's a pain in the butt, but it's a court process. When someone passes away and they have assets that are in their name alone, no beneficiary form, just in their name, such as a house and investments, bank accounts, etc., in order to legally transfer those assets to wherever they wanted to go, we have to go through this court process called probate. What's wrong with probate? Three things that I like to describe as what's wrong with probate. Okay, number one is that it's expensive. You have to pay an attorney like me 3% of the asset. So, as an example, let's say that there's $1 million portfolio and it's got to go through the court system, and that 3% fee is going to be $30,000. So it can add up pretty quickly. In addition, besides my fee, the person that is in charge of the estate, what you guys have probably heard the term executor. In Florida, we call it a personal representative, or PR. They're entitled to a 3% fee as well. So technically, it could be 6% of the fee is gone because of expenses. That's number one. Number two, it takes a long time. The probate process takes a long time. On average, that probate process takes around 18 months or longer. In Florida, when I do a probate, I have about 20 to 25 probates going on right now. When I start the probate process, the courts make me sign a document saying I'm going to do the best I can to close this probate out from start to finish in 1 year. Unfortunately, Carline, that normally does not happen. It's very hard to do. Usually it's about 18 months to 2 years, and if there's litigation, it's several years. And here's why. As example, Broward County, I believe there's only 3 judges at this time that are probate judges. So there's a lot of people that passed away. So there's a lot of cases, and there's only 3 courts that can handle it. So obviously you get backlog there. In addition, judges go on vacation just like you and I. In addition, judges get sick like you and I. In addition, there's emergency hearings and things of that nature. So you can see how quickly, just like that things get delayed. And then let me give you an example of just the beginning of the probate process so you understand what happens. So once we start the probate process, I have to prepare all these opening documents. And then the client has to sign all these documents. Then I have to send it to the court. And if everything is a good order, then the court's going to issue a case number. Once they issue the case number, then I have to send them the death certificate and the will and wait for them to receive it. Once they receive it, I send in all the opening documents with the case number on it. And then I wait for the court to sign something called letters of administration, which is a document that names the executor, or what's known in Florida as a personal representative, in charge. Once we have the letters of administration starting the process, I then have to publish in a newspaper for 2 weeks in a row. And then I have to wait 3 months to see if any creditors file against the estate. That's just the beginning. So that's 3 to 5 months before we even started. So you can see how quickly it can take the process over a year. So again,
That's a long time.
It's a long time. So the probate process, 3 problems. First, expensive. Second, it takes time. Third is that it's public record. A lot of people like to keep things private. I know I tend to be a private person, although when I talk in my workshops, I talk about a lot of personal things to make people understand. But in general, I'm private. So the probate process is public, and a lot of people don't like airing their public information. So that's what's going on with probate. And what happens here, if you die without a will, which remember, that's called dying intestate, what happens is we go through all the hassles, delays, expenses of probate. At the end, the judge says, where's the assets go? And we look at the Florida statute that tells us where the assets go. Remember the Florida intestate statute. If you die with a will, we go through all the hassles, delays, expenses of probate. At the end, the judge says, where's the assets go? We look at the will, and the will tells us where does it go. So either way, testate or intestate, we're going through the court process. And again, I explained how the process works. It's expensive, it's time consuming, it's public record.
And Andrew, earlier you talked about college children, right?
Yeah.
Even though they're so-called adults, but they're technically children. And my husband and I, our oldest daughter is in college. If you're wondering how I'm this young, it's because she's not my biological daughter, but she is my daughter. And we never thought about anything like this for her because we still consider her a child, but technically she's an adult.
Yes. So that's the problem. So I can tell you that I've had several calls from clients that did not do what I told them to do, and the kid got in an accident. One of them was a serious accident up at University of Florida, and they get the call in the middle of the night that your kid was involved in an accident, and they wouldn't talk to them. The doctors would not talk to them legally because they couldn't, because they're 18 years of age. They had to get in the car, drive 5 hours to University of Florida, and talk to the doctors once the kid was awake, etc. But if they had their proper document, and in that situation, the document would be a healthcare surrogate, that if they had that document, then the doctors could have talked to them from a distance. So yeah, I know the kids, we look at them as kids, and they are kids, but legally at 18 years of age, they're an adult, believe it or not. So that's how that works. All right, now let's talk about topic 3 quickly, and that's called titling of assets. And that's a really important topic. I have a whole section. I get into great detail on it. I'm just going to skim the surface on it here. But the titling of assets is really important for estate planning to determine whether we should do wills, trusts, or whatever needs to be done based on the asset titling of things. So what I want to talk about is what happens when you do die. Well, it actually depends on the titling of the asset. For instance, here's a rule. If you have an IRA, 401k, life insurance, annuities, those all have beneficiary forms. Normally, if there's a beneficiary form, that will not go through probate. That avoids probate. When does it not avoid probate? When the person forgets the name of beneficiary and the person dies, that's a problem. Now it goes to the estate and we have a probate. Or when someone forgets to update their beneficiary forms, and that's why I meet with my clients yearly to go over things, but they forget to update the beneficiary form and the beneficiary that they named passed away, and then the person passes away. Now we got to go through a probate process for the estate of the person that died. So normally the general rule is anything with a beneficiary form that avoids probate. Also remember that you can do something called TODs or PODs, transfer on death or payable on death, which are a beneficiary form for bank accounts. So that's another way in the right situation where we do some estate planning. So what normally happens is when you die, again, it depends on the titling. Here's an example I like to give because I see it all the time. We got Mary, who's a widow. We got 3 children. She wants it to go a third, a third, a third to all 3 children. And she sets up her will and does everything that way. However, one of the kids, Cindy, happens to be down here in South Florida locally, and the other 2 kids, one's in New York, one's in California. So she wants Cindy to help out. She's older. So she puts Cindy on a bank account so that Cindy can write checks and do things. Well, Mary passes away, and guess what happens? Let's just say that bank account had $30,000 or $40,000 in it. That bank account is now part of Cindy's assets, not Mary, when Mary passed away, because Mary and Cindy had a joint account with rights of survivorship. That's a titling thing. So whoever survives who. And in that situation, Mary, unfortunately, disinherited the other 2 kids to the bank account. It's not what she wanted. So in that situation, Cindy could keep that bank account of $30,000, $40,000, $50,000, and the other 2 kids could do nothing about it. And then everything else would go towards the will, a third, a third, a third. So in that situation, Mary unintentionally disinherited kids. So there's a right way and a wrong way of doing things. That's not the right way, but I see it every day. So that's an example.
I can see how the example with Mary and Cindy can be such an issue for our seniors, especially for the children of the sandwich generation. Usually you have one person, one child that is in charge of everything, and they pass on information to the others. That's something for parents to think about as well.
Absolutely. So what I would have done in that situation, Carline, is instead of putting the kid that's responsible for everything on that bank account, you should have done in that situation is probably do a TOD or POD, transfer on death or payable on death, a beneficiary form to the bank account, children, all 3 girls in that situation as the beneficiary, so it will go equally all 3. And then put the one child that's here, put them as a fiduciary on the account and give them the right checks and to have access to things. That's how it should be done. So yeah, that's a small tweak to an estate plan that we have to do to make sure things are done properly. So let's talk about homestead for a quick minute. Homestead's very confusing. We're going to talk about 2 things. We're going to talk about homestead protection. We're going to talk about homestead real estate tax. Homestead is creditor protected. So that's one advantage. So God forbid you were to get sued. One thing they cannot come after is your homestead property. No matter how much they want to come after it, they can't touch it. So that's why we want to have a homestead, because it protects the house. That's number 1. Number 2, homestead has an advantage for real estate taxes. By Constitution, the Florida Constitution, they meaning the state, can never increase your real estate tax on your homestead property more than 3% per year. That's the most they can increase. So let's say my property increased 10% from one year to the next. They cannot increase the real estate tax 10%. They can only increase it by 3%. So the advantage is over years and years and years of owning a property, my real estate taxes don't go up that much, which is great. And then what happens is when I pass away, my kids will get the fair market with the date of death value. So as an example, let's say I bought my house for $350,000 and it's worth $1 million today. So at $350,000, I bought it and I get my taxes based on $350,000. Every year it goes up just a little bit. And then I pass away years later and it's $1 million and I want to give it to my kids. Well, that growth from the 350 up to the million is called capital gains growth. Today, it could change, but the advantage is that all that growth, there's no tax on to the kids. So they get what's called a stepped up basis. They'll get it for $1 million with no tax. They could sell it tomorrow for $1 million and not have any tax on the growth. That's one advantage of having a stepped up basis. The disadvantage for real estate taxes, let's say the kids get it now and they want to keep the property and they want to claim homestead on it. The problem is that the county is going to reassess the real estate tax to the date of death value. So mom and dad may have been paying $6,000, $7,000, $8,000, $9,000 a year in taxes, and now it's worth $1 million, and we get it, and the kids want to hold on to it, and the county's going to reassess it, and the tax might go from $8,000, $9,000 to $15,000 to $18,000, and then the kids are saying, "What do we do?" And a lot of times they can't afford it, so they have to sell it. But there's no way to avoid that reassessment. So that's homestead.
I'm so happy that you covered that, because a lot of us parents with children, one way we plan to pass generation wealth is through real estate. And so what we've come across, even with people that we know, their parents pass away and they leave them a piece of wealth, which is real estate. And then you hear that it's in foreclosure. So parents, take notes of this.
So a couple things. Just remember, even if you have a mortgage on the property, that mortgage still has to be paid when the kids take it over, or else it can be foreclosed on. Okay?
Mm-hmm.
So you need to either take over the mortgage and continue payments, or you need to go get refinancing, or you need to just pay it off. But assuming that there's no mortgage or anything at that point, they get it with that huge growth with no tax, which is great. But the real estate tax is going to potentially be a problem for the next generation. Hopefully the kids can hold on to it and keep it in the family. A lot of times they can't and they have to sell it, but it's still, you get all the advantages of the growth on the sale. So that's the homestead issue. Now I'm going to just quickly talk about other titling of assets, explain the difference. And I'm going to use real estate as the example. We're just going to talk about two different types. Joint tenancy with rights of survivorship. So Carline, you and I own a property together, an investment property as joint tenants with rights of survivorship. And I die, you get the property now, 100%. My interest in it is gone. That's what joint tenancy with rights of survivorship means. It goes to the survivor. Got it?
Mm-hmm.
There's another type of ownership where you and I can own a property together as tenants in common, and then I die. What happens there is I keep my 50% that I owned, and it goes down to my family. So joint tenancy with rights of survivorship goes 100% to the survivor. Tenants in common, you keep your interest in it. If you have 3 people involved in a property, it's a third, a third, a third. You keep your third if it's tenants in common. If it's 5 people, you keep your 20%. Each person owns 20%. So that's how it works. Joint tenancy versus tenants in common. And you can own investments like that. You can own, stocks, bonds, mutual funds, all sorts of things like that. So let me ask you a question. Does joint tenancy with rights of survivorship avoid probate court, which we talked about earlier? What do you think? Yes or no?
I would think no.
Okay. So joint tenancy does not avoid probate, but you're cheating because you were at a prior workshop, so you know.
I think I said that earlier. Yeah, she was at the workshop with her husband, so she knows.
What people need to understand is that what happens with joint tenancy is when one of us dies. Carline, you and I, we had that property together and we owned it together as joint tenants with rights of survivorship. I die, now it's yours. There's no probate on that first death. It went right to the survivor. Now you pass away. When you pass away, it's in your name alone. Now that's probate. So joint tenancy does not avoid probate. Joint tenancy delays probate until that last person dies. That's a big distinction, and I want to make sure people understand that, okay?
Especially with the husband and wives. Usually when they buy, they purchase joint Tennessee, right?
So a husband and wife own a property together. The husband dies. The wife now gets it. It's fine, no probate. But now the wife dies. Now we have a problem because it's in the wife's name alone, and now it's going to go through the court system, probate court, to get to the next generation. So that's why it's important to understand that, and that's why you got to do proper planning. Now, children on bank accounts. I see it all the time. We get kids on accounts. It's done all the time. It is what it is. But what you need to know is that it's danger. It's a problem. Here's why. Let's say I have a bank account and I got $20,000 in the bank account. And I got my son Jason on the account with me. And God forbid, for whatever reason, Jason gets in a car accident and it's his fault. And they decide to sue Jason. Well, guess what? That bank account with Jason's name on it, even though it's mine and his name is on it, that bank account is now subject to the lawsuit. What happens if Jason's not very smart investment-wise and has to file for bankruptcy? That bank account's now subject to the bankruptcy. What happens if Jason has to go through divorce? Well, that bank account's subject to the divorce. So again, I don't like to put kids on accounts because if they get divorced, if they have lawsuits, if they have bankruptcy, it's going to be subject to it. The better way is, like we talked about with that Mary and Cindy example with the kids, is to put Jason on as a TOD or POD on the bank account. So if I were to pass away, Jason's a beneficiary on the account. And then if he were to get sued or file or have to file bankruptcy or something, they couldn't touch it because he has no rights to it. He's only a beneficiary to the account. So again, that's talking about, I did it real quick and I didn't go into depth, but that is talking about titling of assets and the importance of titling of assets.
Thing I do want to mention about that, especially in my community, in the Haitian community, we are quick to say, oh, we're going to go and add my child to the bank account and it's going to solve all this problem. Did you just listen to what Andrew just said?
Do not do that. You need to talk to me or meet with me and discuss options. Understood? That is a disaster waiting to happen. One, you're going to disinherit your kids, other kids, if you do that. And two, you're opening yourself up to all sorts of problems with litigation, potentially. All right, quickly, I'm going to try and get through the rest of it real quick. So we're going to talk about ladybird deeds. What you need to know is that there's only 5 states in the country that allow this thing called a ladybird deed. Florida is one of them. The other 4 states, Michigan, Texas, West Virginia, Vermont. I have no idea why those are the states, but that's what they are. Here's what you need to understand. It's wonderful. I use it all the time for estate planning. And what it is, I'm going to use an example. My wife and I own our property together currently. I have 2 kids. I do a new deed to my property, transferring the property from my wife and I to my wife and I. So same thing. My wife and I still own it fully. If I were to die, my wife gets it. She can do whatever she wants with it. She can sell it. She has full control. However, if my wife dies, normally, Carline, there's that probate that we talked about, right? Husband, wife, husband dies first, then the wife dies, probate. But the ladybird deed allows us to name a beneficiary on the deed. So what we did is we named our 2 kids as the beneficiary on the deed. So what I did is I transferred the property from my wife and I, did a new deed to my wife and I, and the beneficiaries were my 2 kids, if we still own the property. And that avoids probate court. Again, it's a wonderful vehicle to use, but it's not meant for every situation. Remember how we talked about the scenario with a divorce, bankruptcy, lawsuits against the kids, etc. That could be a problem if any of those kids are in those situations. So there's better ways to plan for that. You'll have to meet with me to figure that one out because it gets a little too complicated. That's the ladybird deed. Next topic, what I consider the 4 most important documents. It's not a will and it's not a trust, okay, which is what everyone thinks it is. The 4 most important documents, in my opinion, this is my opinion, the durable power of attorney, the healthcare surrogate, the living will, and the HIPAA. Those are the 4 documents. Let's explain what those are. Durable power of attorney. What happens? We've been talking about when you pass away, how to avoid probate court, right? Or how it works. What happens if you don't pass away? What happens if you become disabled or incapacitated? Then there's a whole separate court system over here called guardianship court, which is a disaster. You ever heard of the Britney Spears in California, you know, the singer?
I don't know that story.
Okay, so Britney Spears is a singer, a pop singer, and she ended up having mental problems. And so the father filed for a guardianship, and basically the court named her father in charge of the guardianship, and he ended up controlling her assets and did a lot of funny things with the money, and it became a huge
Wow.
fiasco. So the purpose of a guardian, a durable power, is to avoid that whole court system if, God forbid, you become disabled. So how it works in Florida, it changed. It used to be something called a springing durable power, which was much better many years ago. And what happened there was that if the durable power didn't spring to life until we had doctor's notes stating that you were disabled or incapacitated, and then it would spring to life. And it would work, and you'd name your kids to handle your finances or whatever, no court system. The problem with that is that the banks and the investment community didn't like it because it was too hard on them to determine if you were disabled or not, because they needed to see doctor's notes and all sorts of things. So they lobbied and they got rid of it. Now we have what's called a general durable power of attorney. And what that means is that as soon as we sign that durable power of attorney, it's up and running and it works. And if you become disabled, it will continue to work. Big difference. So I tell people, whoever you name, keep your durable power of attorney, the original documents, close to your vest, because they could take those documents and they could clean your bank account out if they wanted to, if they had access to them legally. So that's a durable power. The other three documents, healthcare surrogate, okay? The healthcare surrogate. Carline, what happens if, God forbid, you get in a car accident and you're unconscious and you broke your arm? You get rushed to the hospital. The doctor can do 3 or 4 different procedures. He can do surgery, not do surgery, a couple other options. He wants to talk to you about which way to go, but you're not awake. Who can make that decision? Who can stand in your shoes? That's the healthcare surrogate.
Recently, a friend of mine, their parent, they were diagnosed with having dementia, and they don't have any of those paperwork in order.
You end up having a guardianship.
And you said that one is a nightmare. And it was sad to see, because had they planned ahead of time, they could have avoided all this issue. I know most of my audience are people from the sandwich generation, people who are opening assisted living, people who are operating assisted living. If someone reaches out to you and they need to come live at your ALF, you need all of those paperwork. And so talk to the person. If they don't have those paperwork, have them reach out to Andrew and make an appointment and get those things going.
You usually need, listen, when I meet with clients and they're in a Medicaid situation or going to an assisted living or nursing home situation, they usually don't have what they need. So 2 of the documents we almost always have to create is that durable power of attorney and the healthcare surrogate. Those 2 documents, that's how important these 2 documents are. Again, I said there's 4 that, in my opinion, are most important. That's why these 2 are so important. So that's the healthcare surrogate. You are 100% correct. And then the next document is that living will, which is also called the dying with dignity or pull the plug document. So what this is that you, God forbid, if you ever have to be put on life support, that you're telling the family what your wishes are, so they don't have to contemplate and make that horrible decision as a family. They know what your wishes are. I've gotten dozens and dozens, if not hundreds of calls over my 30 plus years saying, thank you for having this done, so that we didn't have to worry about what mom, dad, brother, sister needed because they were in that situation. So again, that's the living will, also called the dying with dignity document. And then the last document is called the HIPAA. And what that is, people don't realize this, but what happens if we need to get access to medical records quickly? The hospitals and doctors don't like releasing those documents because there's so many rules and regulations. They have to with the HIPAA. Why would you want it? What happens if, God forbid, your mom's in the hospital unconscious and she has an infection? They want to put her on a medicine, and we need to find out whether she's allergic to this medicine. You don't know it, and we got to look at the records. Well, how do we get access to these records quickly to make sure we're not giving her a medicine she's allergic to? That's why HIPAA is important. So again, those are the 4 most important documents. Next, we're going to talk about trusts real quick. There's irrevocable and revocable. We're talking about revocable. Revocable means changeable. So you can set it up, you can do amendments, nothing set in stone until you pass away. Here's all you need to know about trust. And this is how I describe it. There's 2 steps. The first step is we got to sign it, witness it, notarize it. We got to create the trust. That is step 1. At that point, think of the trust as this empty box that I'm showing on the screen. Step 2, the legal process is called funding or populating, fancy legal term, for basically putting assets in the box. Any assets that are in the box when you pass away, avoid probate court, and go like what you guys think of as a will, go to your kids or grandkids or however you want. And it's that simple. That is trust, and that is the funding process of trust in a nutshell. Now, there's a lot of details that I didn't go through, but you understand the basics of that. And that's what I need you to understand. So that ladybird deed, if I did a ladybird deed transferring the property from my wife and I to my wife and I, and then I did the remainder interest to the trust, not to my kids, to the trust, that's a way of filling up the assets with the trust by putting the house in there. Changing title of investment stocks and bonds and bank accounts to the trust, you're filling up the trust. Why do we need to do trust? Again, we have kids under 18, grandkids we want to leave money to. We got kids that have special needs. We got kids maybe that are not good with money. We want to do it over time so they don't blow it all. We got kids that maybe are married to a spouse and we're not sure it's going to last. We got kids that are not financially stable. We got kids that are going through the divorce. We got lawsuits pending. Those are all reasons to set up trust work. You own a business. We have to do trust work to make sure the business doesn't go through the court. So again, that's a private discussion that needs to happen. I'm just trying to give you the general scenario.
And the beauty of it is the fact that you not only go through and do these things and give your advice based on your 30 years plus experience, you also review your clients' paperwork yearly to make sure, in case they forget, that they have someone that they can come to and make sure they keep things in place. And I thought that was really amazing that you do that as well.
Yeah, I have something. Let me get to the slide real quick. I have this thing I created this year. It's called a State in One Place Private Client Group. And what it is my clients get access to a lot of things that I offer. And I charge a yearly fee for it. But for the rest of this year, the first year out, it's free. One of the things I created something called a legacy portal. So what happens is when people pass away, the family comes in and they don't know what the assets are, where they are. They don't know what liabilities are. They don't know the usernames or passwords to any of their social media to turn things off. They don't know whether they're supposed to be buried or cremated. They don't know where their legal documents are. It's a disaster. So I created a separate legacy portal where you, the client, creates it, and you put in all that information in a private area and then have the username and password available for your family so that when you do pass away, they can go there and they have a snapshot so they know what's going on. In addition, I created monthly Zoom office hours where they can ask questions on a monthly basis and we record it and answer the questions and they can look at it. In addition, I do exactly what you talked about. I charge $500 an hour to meet with clients, but it's built into this private client group. I want to meet with them once a year to go over and review things because things change. I tell people estate planning is not static. It is dynamic. Things change. You have to constantly look at it. So we do that private meeting. In addition, I have minor changes that happen to the legal documents. It's all built into that service fee. Plus, I do private workshops. So that's all something that I created for my client group called the State in One Place Private Client Group. The last topic I want to talk about quickly is the Medicaid planning, which obviously, Carline, you're familiar with. But what I need you to understand is that in Florida, we're very lenient towards Medicaid planning. Thank goodness. A lot of states are not. People hear about this 5-year look back. So if we want to get people qualified for Medicaid planning purposes and you move assets to kids or to an irrevocable trust or anything, and you have to look back 5 years, which is correct. It's a 5-year look back. However, in Florida, thank goodness, we have the ability to do what's called crisis Medicaid planning, which means that I could do things technically almost overnight and move things around legally to protect the income and assets to get someone qualified. What you need to understand about Medicaid planning and nursing home and assisted living and home health care, how does that get paid? That's really what we're talking about. The best way to have it paid is if you have long-term care insurance. Unfortunately, most people do not have long-term care insurance. So then what happens is your income and your assets pay for the assisted living or nursing home until your income and assets are dwindled down to nothing, and then Medicaid will kick. So the problem is, how do you protect your income and assets so they don't get dwindled? Because it can easily, all of those years of building up all these things could go away overnight because it's very expensive to live in a nursing home. So that's one thing we can do. And remember that in today's world, the income, there's 2 thresholds. You have to pass both in order to get Medicaid. The income threshold is if you make more than $2,901 per month. That includes everything: Social Security, IRA benefit, income coming in, pensions, everything. If you have more than that, you will not qualify. If you have assets more than $2,000, you will not qualify. So I have to create legal documents to move the income and to move the assets into things where it will legally be allowed so that we can get you qualified for Medicaid and not lose the income and not lose the assets. So that's proper elder law estate planning. I hope I didn't confuse anybody, but you really should come to one of my workshops to really get the full benefit of the explanation and the question and answer.
Thank you so much, Andrew. And listen, what he just covered, did you get that? How he can legally structure your money so that you are able to meet Medicaid requirements so that you can be approved if you meet those requirements. Okay, did you hear that? Because I come across people that are asking questions about how do I get my parents approved for Medicaid? Schedule a call with Andrew's office. His teams are amazing. They will follow up with you. I met some of his other team members, Carlos. Let me tell you, those people are amazing. And Andrew, thank you so much for covering this. I have a couple of questions that I want to ask you. And simply because of the audience, they might want to know, do you work with assisted living facilities and care homes with
Yes.
those type of documents?
Yes, I do that every day. In fact, yesterday I had two scenarios of two families where we had to do what we just talked about. We had to file things by the end of May. So we had to overnight finish things up to try and qualify and get them filed and do the application process for Medicaid purposes. Yes.
Yes, absolutely. I mean, you pretty much cover everything my client will need, to tell you the truth. The paperwork for admission, how to get their residents approved for Medicaid, because sometimes we come in thinking we're caring for the seniors and we end up caring for their children because we're like, they start asking us, where do I do this? I'm feeling X, Y, or Z. What do you think I should do? Next thing you know, you're fixing the whole family. As long as they trust you enough, they will allow you to fix them.
Listen, the Medicaid process is pretty complicated, believe it or not. Unfortunately, we try to make it not complicated and explain it so that you understand it at a level that makes sense and why we have to do A, B, and C to get you qualified or get mom and dad qualified.
The best way to get the most out of him is to schedule a time with his staff, get to speak with him, or if you're locally, go to one of his events and one of those workshops, because sometimes you simply don't know what to ask, but then someone else will ask something. We're like, oh, I needed to know that, but I didn't know to ask that. So attending one of his workshops, I attended one with my husband, and it was very valuable. Andrew, thank you so much for being here. Is there anything else you want to say?
No, but first off, thank you so much for inviting me to your podcast, and I hope I brought some value for everyone out there. I will say this. I have had several people go to multiple times to my workshops because they heard it first, and then there was a lot of material, and they needed to hear it a second time, and more questions popped up. So a lot of times I see people there 2-3 times, and then they schedule meetings with me. So it's kind of funny to see.
Yes, and you also go deeper into different topics, because I remember when I went, you talked about another topic that you were going to go deeper in on the next workshop that you were having. And so it's worth going over and over until you can make a decision and then schedule that call where you will get the most out of it. So yes, I am grateful that you're here. I'm pretty sure you've delivered so much value. I feel it myself. Even today, I learned even more. And so I just can't seem to get enough of this type of information, because it's truly knowledge that set people apart. If you don't know what to do, you don't have the proper resources, you're just lost out there. And so we bring you these amazing guest speakers, very knowledgeable, have been doing this for so many decades. And so take advantage of it. Schedule that call. Don't procrastinate. And so until next time, share this with your family, your friends, right? Don't keep everything to yourself, and make sure that others in your audience as well, in your family, get the knowledge, because you don't just want to be the only one with the knowledge. You want to share it. Okay. So until next time, I look forward to serving you more. We'll see you in the next video.